number 106, matter of Plastic Surgery Group versus the Comptroller of the State of New York. Counsel?
Thank you, Your Honor. Good afternoon, Your Honors. Matthew Dodora for the appellant, the Plastic Surgery Group. I'd like to reserve 3 minutes for rebuttal.
Yes, of course.
When the state legislature conferred upon the Comptroller the authority to issue subpoenas, it expressly conditions subpoenas issued pursuant to that authority on the entirety of the CPLR. And CPLR 3122...
So let me ask you this. 3122D says that the party seeking disclosure must bear the expense. Does that provision apply here also? So the Comptroller has to bear whatever copying costs or whatever cost there may be in getting this discovery. Does that apply?
I think it likely could, if under certain circumstances, I think it could apply. But what we're talking about here, we have an express...
And if you're correct that the subpoenas are subject to 3122, who's going to carry the burden of securing these actual patient signatures from these 78 individuals? Who has that burden before the Comptroller can then conduct the audit?
Well, in that instance...
the facility that has the records? Is it going to be...
Sure. Well, I think if it's the Comptroller that wants the records and they have to get authorizations, it would be the Comptroller that would have to get the authorizations. But there are ways that the Comptroller...
So they're going to get a list of who these patients are and their contact information and then go around and seek it? And
well, presumably...
Have you already disclosed too much in doing that?
Presumably, the Comptroller would already have that information because through United. I mean, they've identified the 1,500 patients that fall within the scope of the audit. So presumably, the Comptroller has all the information that it would need to send out authorizations. But here, the Comptroller's office, and this goes back to what the third department said about that to require the authorizations would eviscerate the Comptroller's ability to conduct these audits. And I simply don't think that that's the reality, because first of all, there's nothing in the record to support that. It's a purely speculative conclusion. But furthermore, there are other ways the Comptroller, or other means at the Comptroller's disposal to get the information that it needs. As I mentioned...
Could they have requested, and I believe they did, redacted information, patient records?
If they had requested redacted records in the subpoena, one of the issues is who bears the expense of redacting that information and how much information has to be redacted. 3122 does not speak in any sense to, redacting records. They served a blanket subpoena for patient medical records, and the plain text of the statute, which controls here, says that a subpoena to a medical provider, other than a trial subpoena issued by a court, requesting patient records must be accompanied by authorizations. I mean, the statutory language is plain.
Talking about the statutory language for a second, when you look at 3211-2A, pursuant to this rule, what rule are we referring to here?
3122A2. In other words...
Well, is that correct? Because the CPLR refers to both rule and sections. The way I understand the history of that is that there were rules and then there were statutes that were incorporated together. I think in '62 is when that took place, and that's why you have those two different distinctions. As you read the statute, you'll see rule, section, rule, and it isn't the same. Now, it seems to me that 3122 is actually referring back to 3120, which is the rule that precedes it. It's clearly not referring to 3121 because that's the medical discovery rule. So I don't know if your reading really bears analysis, is what I'm saying.
Well, I think it does, because 3122 is talking about specifically how you would go about subpoenaing medical records from a provider. And the subpoena has to have certain language on it, disclosure language. So they say, if you're subpoenaing a medical provider and you're doing it pursuant to this section, you're following the requirements of this section. That's why I think pursuant to this rule is an internal reference to the statute, to that section itself.
I see. That's not, it's not an unreasonable reading of it. I'm not sure I agree with it, but it's a reasonable reading you say of it. But it's really more compelling to me is, what kind of subpoena is this? Is this a discovery subpoena, or is it an investigative subpoena?
Well,
and can that distinction be fairly drawn, I guess, is really what we have to look at.
the CPLR doesn't distinguish between a discovery subpoena and an investigative
You're right,
subpoena.
but there are things that do. For instance, the sponsors memorandum for 3122 quite clearly refers to, let me quote it to you. It says, into the bill jacket in 2011, and in talking about 3122, and that 3122 requiring patient authorization applies only to subpoenas issued during discovery. Also, the OCA memorandum and the memorandum in the bill during discovery, and the no objection letter from the State Education Department. All of those communications seem to support the reading that 3122 specifically refers to patient authorization applying to subpoena justicum in this sense only during discovery.
But if we look at the text that the legislature actually adopted, and you go back to 2301 of the CPLR, that identifies 3 subpoenas: a subpoena to attend and give testimony, a subpoena to produce books, records, and things, and a child support subpoena. 3122 and State Finance Law Section 9, for that matter, they track that same language. There's no language anywhere in those 3 statutes that talks about an investigative subpoena or a discovery subpoena. They talk about subpoenas for books. And 3122 talks about a narrower subset of subpoenas for books, where the books are medical records and the subpoena is sent to a medical provider.
Don't you have to also take this in the broader context of the CPLR as a whole? Would you say that's what applies here, the CPLR as a whole?
Correct.
I think there's a pretty good argument that only those provisions of the CPLR that apply to this situation apply, but be that as it may. But you have Article 23, and it talks about subpoenas generally. Then you have Article 31, and that's talking about discovery and trials and actions that have been commenced. And this falls within that article. And not only that, it was originally part of A1, and then it was separated out, and I can't find anything in the legislative history that would indicate that in doing that, the legislature intended to make those separate in terms of their application. So don't we have to consider all that, I guess, is my question. And
We can, but
and if not, why not?
This court's precedents in Squadrito and Ministers, it talked about the limited usefulness of headings and titles because of the fact that the legislature does its best to group related things together.
If that were it, I would say you have a very strong point, but I'm not just talking about the titles. I'm talking about the entire context
Sure.
and how the whole CPLR is organized in this regard.
I think if you took 3122A2 as written, and you lifted it up and you put it in Article 23, I don't think there'd be any doubt at all that the controller was obligated to comply, in this instance, with that section. And if that's the case, that's based on the plain language of the statute. And if we reach a different result now, just because it's in Article 31 as opposed to Article 23, aren't we then elevating titles above the plain language of the text?
But you're also ignoring the pursuant to this rule language, or assuming it means what you think.
Right. I think that, there's a consistent way to read that phrase pursuant to this rule, and everything else that this court has said about statutory interpretation and the usefulness of headings, that is all very consistent. And when we go back and we say, well, as the controller says in their brief, that, it only means the provisions of the CPLR that apply in this instance. Well, in this instance, we have, I see my time is
Continue.
up, but if I could just
Finish up your answer.
to say it only applies, well, in this instance, we have a provision of the CPLR addressing subpoenas to medical providers for patient records. And there's one section of the CPLR that addresses subpoenas to medical providers for patient records. This is the one section that has to apply to this case.
Thank you,
Can I?
Yes, of
was
course,
there-
of course.
Thanks. Just one point off of that point, not on the same point. You abandoned your HIPAA contentions. Is that correct?
I'm certainly not raising a HIPAA contention here because I don't think HIPAA gets to the final point, right? HIPAA is just you can,
The reason
if you
I
want
asked,
to.
let me tell you why I'm asking.
Sure.
Because I want to know if you concede that the Comptroller's department is a health oversight agency.
I do not concede it. It is not relevant here because if it is a health oversight agency, and I really specifically didn't go into that even in the underlying petition because it doesn't address the final point. Because even if it is,
You're saying even if it is, they still
it
don't
just
have
means
this authority.
may. It's not you must. Must gets to subpoenas is how you get to must, and that's what we're addressing here.
Thank you.
Thank you, counsel. Counsel?
Good afternoon, Your Honors. Jeffrey Lang on behalf of the Comptroller. Just to pick up on the last point, the Comptroller is a health oversight agency within the meaning of HIPAA. That was argued below. The Third Department found that the Comptroller was, which is consistent with the HIPAA regulations, and petitioner hasn't argued to
As
the
I
contrary.
understand, the thrust of petitioner's point is that when you look at the legislative history, however much that may work against us, you don't get to that because the plain language is dispositive. And I think you should start there.
The plain language is dispositive in our favor, so you don't need to get to the legislative history, and that's for three reasons. One, the placement of CPLR 3211A2 in Article 31, which concerns disclosure in the prosecution and defense of an action. So we're not talking about a conflict with just the heading and the substance. The substance concerns the prosecution and defense of an action. And the second is the position of A2 juxtaposed to A1. Now, petitioner concedes that A1 only concerns pretrial discovery subpoenas, and that's absolutely right. A1 concerns the procedure for objecting to disclosure sought by a document subpoena, quote, under Rule 3120 or Section 3121, and document subpoenas that are issued under Rule 3120 are those that apply, and then it's just a quote from the CPLR, after commencement of an action. So it's clear that 3122A1 only applies to pretrial discovery document subpoenas. And then if you go to the plain language of A2, that also supports our argument because it refers to a medical provider served with a document subpoena, quote, requesting the production of a patient's medical records pursuant to this rule. Now, this rule can only sensibly be read to refer to Rule 3211
But that's not what
as a whole.
that's not what Counselor says. When it says when they're saying this rule, he's saying he's referring to the rule that you're speaking of, 3122.
It refers to, well, his argument, as I understand, is that it only refers to what I would call subsection or subdivision 3211A2, which in their view is just a freestanding subsection that applies to all subpoenas, which takes that subsection completely out of context. And our argument is that even if you look at the language of the subsection pursuant to this rule isn't this subsection. The CPLR has articles, it has rules, it has sections. So when it says this rule, it must mean the rule as a whole. So you look at the rule as a whole, and again, when you look at the rule as a whole, it's clear that it applies only to pretrial discovery subpoenas.
What are you calling the rule as a whole?
The rule as a whole, I'm calling CPLR 3211 the rule, which has 4 subsections. It has A, B, C, and D. So Judge Stein asked about subdivision D, and again, the answer to that question is it reinforces that D does not apply to the comptroller's subpoenas. It just reinforces the litigation context. It says that the reasonable production expenses of a non-party shall be defrayed by the party seeking discovery. That just reinforces the litigation context. We're talking about parties and non-parties to litigation. We're not talking about the comptroller's investigative subpoena.
So then A2, when you say this rule, you mean the rule in which this subdivision is contained?
Precisely.
Okay.
And, if there were any doubt, I mean, the context in the plain language supports our reason, our position, but if there's any doubt, if you just look at the legislative history that of 3122A2, that further supports our position. It was added.
Are there any, we've talked a little bit about HIPAA, but are there any New York patient privacy laws that speak to whether there's an exemption for the comptroller that you know of?
Not that I'm aware of. There is the New York, the state personal, the state personal privacy protection law. That's Article 6A of the Public Officers Law, and that's the law that requires the comptroller to maintain the confidentiality of this information that's collected for the purposes of
I thought the
these
controller
audits.
under Public Officers Law 92-1 was bound not to disclose, too.
Yes, that's in Article 6A, precisely.
I see. Okay.
So that is.
So those
law-
privacy protections that are like patient-physician privileges are in place, you're saying because of this?
Well, I'm saying that the comptroller is bound by Public Officers Law 92-1 and 92-1A, which requires the comptroller to keep this patient, we're talking about patient billing information, confidential. So in other words, when the comptroller publishes an audit after the fact, the comptroller isn't releasing publicly any personal information related to any one individual, so that the privacy interests of the patients here, which are certainly legitimate and important, but they're already adequately protected by.
Why did the legislature separate the two subdivisions in 2011?
The legislature separated them in 2011, and that was because there was a decision that said that trial subpoenas were also subject to this patient authorization requirement. And so that was, the legislature then amended A and split it into A1 and A2, and that was in response to that decision to overturn that decision. And this is where the legislative history again supports us, because this is the Assembly memo in support, which said that in 2011, the amendment was meant to make clear that the patient authorization requirement, quote, applies only to subpoenas issued during discovery, end quote. So not even to all, subpoenas that are part of an action, but only even a subset, that is, subpoenas that are issued in discovery and not trial subpoenas. And A1 was separated from A2 only to make that more clear. So A1, which is what allows a recipient of a document, of a trial subpoena, to raise objections. You can raise objections whether that's a trial subpoena or whether that's a pretrial discovery.
The way I read Handler, your interpretation of the statute in that context would seem to be an expansion of our ruling in Handler.
I agree that Handler is not dispositive, although I would say that Handler establishes several propositions that I think favor the outcome that we're advocating for, which is that the comptroller has the constitutional and statutory obligation to audit these state payments for services provided to members of the state's health care plan. Handler also recognized that a provider's billing and payment records are necessary, and without them, as the court said.
Is there some other way you could exercise and satisfy your duties with respect to the audits, other than by requesting that they turn all of this over without having gotten patient's consent in advance?
There's just no other way to do this. Petitioner had a couple of suggestions that were raised for the
Well, he
first time.
says you know who all the patients are, just send them the consent yourselves.
We're talking about thousands of patients, and this is just to audit one provider. So, and when the comptroller had selected 1,500 records, and that was only assuming that the auditors would be allowed on site. So the auditors need even more records.
Does
So
the
you're talking about-
comptroller otherwise have for any other purpose, have communications with the patients?
I mean, not for the purpose of this audit. The petitioner suggests that the comptroller could seek the billing records from the patients individually, maybe by subpoenaing them. That just wouldn't be practical to subpoena thousands of members of the
It'll go
of
over
the
well,
plan.
too.
I'm
It'll
sorry.
go over very well with those patients.
Yes.
Thank you, counsel.
Thank you.
Counsel?
In a case of statutory interpretation, or really statutory construction such as this, the rules are different than the rules of real estate, right? Real estate, they talk about the most important things being location, location, location. And that's the controller's argument here. They can't address head-on the language of 3122A2, so they talk about location. But nothing in this court's jurisprudence about statutory interpretation addresses location as one of the main factors.
Just to be clear, an A2, what do you think rule means there? What rule is the statute referring to?
3122A2. It is referring to itself.
If we disagree with you on that, does that end the story?
I don't think so, because the language is still clear as to medical providers receiving a subpoena for patient records, that they must be accompanied by an authorization in order for it to, in order to have a valid subpoena that the provider has to respond to.
I'm sorry, what is the rule that you say is in 2, that word rule refers to? What's the rule?
The rule is 3122A2. It is referring.
I understand. What is the rule? I'm asking.
The rule is that when a subpoena is served upon a medical provider, which requests patient medical records, then the provider need not respond to it unless the subpoena is accompanied by authorizations, and the subpoena states on its face in conspicuous type that the provider need not respond unless the
Yeah, but that would mean
authorizations
the
are
word
provided.
rule is placed before you're actually describing the rule, in that sense. It seems to me an awkward placement of the word, whereas it would be much more natural to refer to this as this section, if that's
Well,
what
if
you
it
were doing.
refers to 3122 as a generally, the entirety of it, that doesn't really make sense either, because, for example, in 3122A1, the legislature specifically addressed subpoenas in the context of a pending litigation. But in A2, they used different language. They didn't use a discovery. They didn't make reference to a discovery device. They referred generally to subpoenas ducis tecum,
Yes, I understand, but
which is different than what they did in A1.
Yeah,
So
but
if
in
they
3122A1, they do use the word rule to refer to another rule, and they do use the word section to refer to a section. So obviously, and this was one paragraph, it does seem to me the legislature does understand how to be much more express about referring to the rule that are external to Rule 3122, when that's what they want to do.
well, when they wanted to
Otherwise,
when
they don't otherwise say what you say they mean by rule here, which is sort of within their own little subparagraph, any subparagraph, refer to itself, right? Sort of self-referential, and it uses the word rule. It doesn't really do that anywhere else.
But when they want to refer to a specific statute, they do it specifically. Just like they did in A1. They said Rule 3120 or
Yes, but I think
Section
you're making his
3122.
argument, because that's why you only say this rule, because of course you're dealing with this particular rule it's a part of.
I don't think
Opposed to
I'm making
just the
his
paragraph.
argument. It's rule with a small r, it's not a capital R.
Thank you, counsel.
Thank you.